Do you have a copy of the affidavit which they have filed? Report? Is it okay now?
Yes. Yes.
My lords, I seek your lordship's permission to move an appeal, mandamus appeal without certified copy, my lords.
When the order is passed.
The order was passed in 2021, but the difficulty, they have filed a writ for implementation. So therefore,
Whatever, sir. I have a very strong principle. When a normal period of limitation has expired, we don't grant this.
the difficulty is, my lords, then it will become infructuous. They have moved a writ for implementation of the order.
Whatever, you'll have to say, obtain a certified copy. That's my principle. I never give any leave in the principal seat. Never give. Yes.
I want to mention one matter. What is liberty was given to the petitioner to mention this matter after preparation of paper and serving the bill to the website.
The doc here say, Rako, to be mentioned. Yes, call the list. Let us see, sir, first.
No, I am led by Mr. Vikramjit Banerjee, learned additional solicitor general. He is logged in virtually.
Yes, sir. I can see.
I am appearing for the Students' Council, my lord.
And I'm
On Friday,
debate.
I filed one CAN application, my lord.
My lord, I am for the appellant Pondicherry University.
Yes,
I am for the appellant Pondicherry University.
yes.
CAN 13 I filed.
Manoj, the Ministry of Human, Manoj, there was a direction for Ministry of Human Resource Development to file a report.
Oh,
For declaring the pending results, my lord.
who are you? Are you a party to the proceeding?
Yes,
Which respondent?
added respondents, my lord. Students' Council.
You have been added?
Yes, by the CAN number 4 and 5.
You have been added?
Yes,
You wanted a declaration of result,
not only that, my lord, the law,
but all it depends upon the ultimate decision to be taken in the writ,
my lord,
in the appeal. So if the appeal goes, then automatically, and if the appeal is allowed, then automatic consequences. Both ways.
my lord, provisional affiliation was granted.
No, I do not want to, okay, but the only thing is, they must be challenging the entire, the examination or whatever. Then what they are challenging?
Challenges for affiliation of the
Affiliation.
affiliation.
Suppose if the affiliation is affirmed,
My lord.
then they are bound to declare the result. If the affiliation goes,
My lord.
then definitely your consequences.
Why should we suffer, my lord? I am asking myself.
That is what we will consider at that time.
My lord,
So let us hear the appeal first.
This honorable court granted permission to conduct examination.
Correct.
Various.
Subject to the result of the appeal.
My lord.
So let us see what is the result of the appeal. We have not applied our mind. We have not read anything. Not a single line as of now.
Manoj,
Lordship,
Manoj, may I encapsulate what happened? Manoj, this is a dispute regarding the Pondicherry University and DBRATE, which is the local technical institution, as to on the conditions on which affiliation is to be granted. They were insisting on certain conditions. We were saying some of them could not be complied because of the exigencies of the situation. As what happened, this court on a number of orders had been passed. MRD.
Mr. Banerjee, can you come closer to your audio system because we
Malaj, am I audible, Malaj? Am I audible?
audible, but your voice is somehow, the
Echoing, Malaj. I'll try to get back. I'll try to log out and come back. I'll try to log out and come back. Malaj. Will excuse me, Malaj. I'll log out and come back.
No. You can come closer to your audio.
Malaj, am I clear, Malaj?
Now you are audible.
Malaj, the situation is this matter is regarding a dispute between the Pondicherry University and DBRATE, and I appear on behalf of the local administration. Malaj, the whole dispute was to Pondicherry University had put forth certain conditions for continuing its affiliation for students. DBRATE is this institution which gives technical degrees for engineering and things of that sort. Malaj, so Pondicherry University had insisted on certain conditions to be made. we were there with the students saying that those who had already been admitted should be allowed to graduate and examination should be carried on. Well, the dispute got very heated, and this court, we succeeded before the single judge. The Pondicherry University came on appeal. And in the appeal, this court was of the view that it should be sorted out by the union government, because this was inter se Pondicherry is under the union government, as well as Debrate is also very specialized for these islands, which has great significance for this government here as well as under the union government. And so there was a direction on the MHRD at the first instance to mediate and then to sort of come out with a report. That report is before the court. That has been filed. If my lord goes through it, there's been a detail considering both our sort of condition, our submission saying that we would like some time to comply with the Pondicherry University's orders, and as well as the Pondicherry University putting forward its view. So there's a detailed report filed by the MHRD where we have been given some, it has taken on record we have complied, some of the conditions we have complied, and on other conditions it has given us around a 2-year time period for us to comply. The major condition being that the Pondicherry University was insisting that the engineering and the diploma and the degree course were to be separated. So they said, the MHRD was of the view that it would take some time to do that. And that is the view, that report is before the court. I would also like to just inform the court, because I spoke yesterday at the highest levels, that maybe sometime in future, may not be right now, but we are working on it as soon as possible, that maybe we will have an independent deemed university or some sort of structure for the islands itself.
That's a very
in the. I'm sorry,
good for them.
It started way back in 2018, my lord.
But my information is it's at the highest level and would possibly culminate soon. I don't want to give a timeline because I know how the system works, but I've been assured that it's going to be very soon. But in any case, what we are wanting at the present instance, the students who have taken the exams, their results should at least be published.
Sure.
And if we sort of part, and we obviously intend to part with Pondicherry University with the help of the government, let us part on amicable terms. We are all children of the central government in some ways or the other. And let us not part on bitter terms. That's what I would request my learned friend. Otherwise, if Mallods has seized the report, Mallods will see that timeline has been given and we've been given time to do it. The issue which was arising is because most of the institutions in the islands, are financed by the Home Ministry. And not by the but
No, here itself,
Any day.
on the morning it was heavily.
On the last paragraph, that even it is willing to
Tell him. Mr. Banerjee, actually, there was some technical glitch in between. Mr.
Yes, sir.
Banerjee, can you hear us? He is logged off.
May I make a
Well,
suggestion?
Yes. Because
maybe possibly at our end there may be some problems. Intel always a big thing.
tell him to connect you on an audio system and then you put it before our audio system so that we can.
Malans, this is now I can hear Malans. But Malans, so the report is before the court, Malans, and Malans will take a look at the report and then Malans put it.
Yes.
But one thing
Now
is,
the only thing is that what he says, I think he has come up, I think the government has come up in support of the students. So they wanted that the result to be published.
Yes,
They-
Manoj, yes.
academic
Yes,
were
yes.
to be hampered in any way. And they are in process of, the resolving this, or, trying to settle all these problems which the Pondicherry University has raised.
In fact, Lord, I am for
So-
debate, Lord. I am for debate.
Now I understand.
Yes.
Now understand. So he has at
I am also
least
supporting that prayer, Lord.
the contention of the government, union government, is very categorical. Now we have to hear Pondicherry, because they are raising some kind of may I use the word, a spanner into a good cause. So let us hear the Pondicherry University, because the affiliation lies with them.
Only one thing, Lord. I'll make one humble submission, Lord. As the learned ASG has said, the admissions are not there for the last 2 years in the debate. Only the old students whose results are required to be declared.
For
That's
the
the
time being, the difficulty is, if you are affiliated with the Pondicherry University, then whatever the conditions for affiliation which they have, that has to be followed. There is no, I think there cannot be any quarrel. Nobody will say that will not be followed. Then obviously, when there is some kind of a lapses which they have noticed, the college has committed, then in that event, the present, the admission, obviously, unless those are,
That's not for
that
2
has
years.
to be, that has to be
Stop
for
for 2
the,
years.
but those who have already been
That's right.
admitted, at least their career should not
Be hampered.
be hampered in any way. This is what is, I think, is a
Lordship.
benevolent attempt of all, including the Union of India as well. That's a fair suggestion. So let us hear, I think, nothing more than that except the Pondicherry. Yes, what Mr. Singh,
right.
your client has.
Right.
Be sympathetic to those children. Why don't you hamper those? That is, they have stopped taking admission.
They have not stopped.
Yes, 2 years.
They have not fulfilled the conditions. They have not appointed even the professors. They don't have the lab equipments. Kindly just bear with me for 5 minutes. I am referring to paper book number 1. Some pages I will refer.
Now, after this scenario, what you have to say?
No, even here also, the ministry has not come up with the clean hands. What they have submitted, that they are going to have a deemed university, they not even a single whisper is there.
No. The learned ASG has been very categorical.
I am submitting.
Yesterday, what he perceived from an interaction with the high officials of the government,
I will show
he
you.
has percolated
Manoj
that.
will record my submission.
Also,
There is no issue.
as per earlier then.
No, he says that we are thinking. He has not said that we are going to do that. What he says is we had a talk with them, and we are thinking that if this kind of an impasse can be resolved for all time to come, if and only if this college is considered to be a deemed university. You can't stand in the way. Somebody says, I do not want to be affiliated with you. Can you say you should remain affiliated with me?
If they
All time to come? No.
want affiliation from us, from the university, they have to fulfill the condition of affiliation.
True, that is what is nobody is disputing. That for affiliation, if you have put any conditions, you have to.
How that dispute has arisen.
Now you have to be sympathetic as well.
Well, after I make my submissions, whatever your lordship will say, we will follow. Kindly just listen, allow me to make a submission. Page number 128 of paper book number 1, kindly. This is the letter dated 6/5/2019. The conditional affiliation has been granted.
170,
128.
128. Yes, sir.
This is the letter dated 6/5/2019.
Correct.
Grant of conditional affiliation for the academic year 2019-20.
Great.
Now, observation of the inspection committees are as follows. Shortcomings observed observed during the previous inspection committee should be fully rectified. Teachers' norms or AICT of Indian College is not followed. No separate principal for Indian College, Polytechnic, Catering Technology, latest AICT pay scales, extra, and so on. At the end of this letter, my lord,
Lord, all
Case
this is
130.
taken care of.
please, please.
All of this is taken care of in the report.
Mr. Savanto, please wait. Then Mr.
Fine.
Singh is placing, let him place.
Page number 130, my lord. 130.
Yes.
You may please note that a conditional provisional affiliation for the academic year 2019-20 would be considered only on rectification of the above shortcomings and submission of the compliance report with the supporting documents along with the required undertaking and payment of the affiliation and inspection funds as above. Second part is admission to these courses for the academic year 2019-20 should not be made without the approval of the university, failing which the strict action would be taken against the college. The principal of the debate has been put on notice that please don't make any admission for the academic year 2019-20. Whereas the writ application will show at page 17, my lord, of the writ application. This writ application was filed jointly by the Andaman Nicobar administration.
Now in the paper book where? Now you
So,
are talking
1/7
of the paper book.
paper.
Yes.
Last column 2019-20. Here they have mentioned, what it was?
Yes. 19, 20.
2019.
Last column.
Last line.
Correct.
6 May 2019 has been shown as date of extension of affiliation. Before this code, this has been mentioned by them.
Yes.
This is the date of affiliation, whereas the 6/5/2019, the letter which I have shown to your lordship is entirely different. Got it, my lord? Now, at page 175, 175.
Yes. 175.
My lord, just a minute, just. Ah, 172, my lord, here.
Yes.
This is the letter dated 19th of July, 2019.
Yes.
By this letter, the university has withdrawn the conditional affiliation. Now, whenever the conditional affiliation is withdrawn, then the students already admitted, they will not suffer. Their studies will continue. It is the responsibility of the university, once the students have been admitted, even if the admission is affiliation is cancelled, they will be allowed to complete their course till the end.
No, you have not said in this letter.
In this letter, we have withdrawn, my lord.
That's all.
Yes, my lord. The persistent deficiency and failure of the college management in complying with the affiliation condition of the university, Pondicherry University,
From where you're reading?
page 73, my lord.
73.
Yes, my lord.
173.
173.
Yes. In view of the above persistent deficiencies.
Yes, my lord. Of the college management in complying with
That do affiliation that is withdrawn from the academic year 2019. So
Right.
before that it is not.
it is not.
But
Now,
from the academic year
2019-20.
then
Thereafterwards, another letter was issued by the university on 7/11/2019,
yes,
which is at page 177. 177.
yes,
I am reading through the second paragraph. In pursuance of the action taken report submitted by the Secretary Education Andaman Nicobar Islands, wide reference first cited above and giving due weightage to the interests of the Andaman Nicobar Islands students, Vice Chancellor of Pondicherry University is considering to revoke, to withdraw the letter of affiliation of DBRET, a conditional provisional affiliation to the following courses offered to at demerit Port Blair is accorded for the academic year 2019-20. Now, further, next paragraph, last at page 178. Paragraph number 5, my lord. All other deficiencies pointed out by the inspection committee with respect to the faculty, lab equipments, library books, journals, and sports facilities should be rectified within 3 months. They have been put on notice. By this letter, the earlier letter of 19th of July has been withdrawn. And this comes into operation. Affiliation has been granted. Now what happened? This letter was issued on 7th of November 2019. Thereafterwards, Andaman Nicobar Administration, Principal Debate, jointly they filed the writ application. Writ application was affirmed on 5th February 2020, before the expiry of the period of 2 months. Now, 3 months. Now, in the writ application, I know, what is their prayer? That may kindly listen. The prayer portion is at page, starts from page 35 onwards, and the prayer is B, right? At page 36. Writ oblique order / directions
Which
in the
one? Which one? Which one?
Page 36, my lord.
Yes.
Prayer B.
Yes.
Writ / order / directions in the nature of the mandamus do issue. Questioning or setting aside the imperial letter dated 19/7/2019 that has been revoked by the university itself, as contained in the annexure P/16 here too, and all consequent actions thereunder, as well as the letter dated 7/11/2019, as contained in the annexure P/17. Here too, insofar as the conditions imposed therein and thereupon directing the respondent authorities to grant affiliation to the debate forthwith from the academic year 2019-20 without any conditions and fetters, and further commanding them to act in and proceed in accordance with the law. What is their prayer? That the affiliation should be granted to us without any conditions. This is their prayer. Now, after this was affirmed on 5th of February 2020. They have filed a CAN application. The CAN application starts from page 299. A CAN application was filed by them. 077/2020, and this application was affirmed.
290?
299.
299 is the affidavit in opposition.
Well, 300, page number 300. 300.
Supplementary, this is the
Yes.
Form B.
Yes, next page, my lord.
Anyhow,
This way.
I
300.
think 301, this, what is this CAN?
301, my lord.
What is this CAN?
This CAN
No,
application.
CAN application number? This is blank.
77, my lord. 77
77,
of 2020.
yes. What is the prayer made herein?
Their prayer is at page 314, last page, a prayer. Direction to issue directing the respondent Pondicherry University to forthwith extend the affiliation for the academic year 2020-21 to debate undergraduate programs to enable admission of evening students for the said academic year pending disposal of the writ application.
Yes.
This is their prayer. Now, I just want to bring the attention of this honorable court to para 9 of this application, which is at page 312. Para 9, my lords. Got it, my lords? That the case made out in the writ petition is that the acts of the respondent authorities of the Pondicherry University initially withdrawing the affiliation for the academic year 2019-20 and thereafter granting the conditional affiliation for the period of 3 months. To debate the only Indian college in the Andaman Nicobar Islands is unsustainable both in law and on facts.
From where you are reading.
And paragraph 9 of this application. 312.
What has happened to this application?
Allowed.
That it was granted, order was passed. That order is to grant the affiliation.
Correct. So what is the now?
That is at page 356.
No, what is the point now?
Point is, they have obtained this order by making a false affirmation before the court.
Correct. Did you bring this to the notice of the bench?
Yes, my lord.
Then what the bench said?
I have filed an appeal before the division bench has decided that application.
Yes.
Division bench kept all the points open and left it that the single judge will decide all the points raised by me after the exchange of affidavits.
Now what would happen? Suppose the interim order was passed directing you to give a grant a affiliation.
Yes.
Maybe provisional, temporary, whatever, for the year 2020.
2019 to 2020.
2020.
Yes.
So now this was granted.
Affiliation was granted,
Correct.
but prior to that,
It was 2020 and 2021. This was the case of 2020 and 2021.
Right.
If I correctly understood you, you are just trying to demonstrate that so far as the 1920 academic years is concerned, there was a withdrawal. The withdrawal was well communicated to them. Subsequently, there was another correspondences. You have decided to grant them an affiliation for
Yes.
1920.
yes,
Certain conditions, 2 months' time was given. Now you wanted to say within that 2 months' time means expiry, they approached the High Court by filing a writ.
before the expiry of 3 months, they approved.
Whatever. So that was the time
Right.
limit which was given. Now the High Court entertained it, must have passed certain order.
Full application. That
Now-
application is still pending.
Correct. Now it appears that there is no correspondences which was exchanged for the year 2019-20. That after the 2 months period or a 3 months period expires, then the affiliation would automatically revert back to you.
Yes.
Now that was continuing. 1920, there was no difficulty when academic session 2020 and 21 came. This application was taken out that by this time, please kindly allow me to continue. Interim order was passed.
Interim order was passed.
The students were admitted in terms of the order of the High Court.
In term, the High Court order is very, very important. Division bench order, right? The division bench had categorically said,
Yes.
while entertaining my appeal, that all the points raised by me.
No, that I got your point.
Right.
Question was, there was not a single order which is forthcoming, is staying the operation of the single bench order. Nothing. So the students were admitted into that academic session of
Yes.
2020-2021.
Right.
And whatever you wanted to raise a point or a flag a point, that was kept open to be decided
Yes,
at the time. The question, the bottom line of the factual story is that the students were admitted for academic session 2020-2021.
Yes, boy.
Now today where we stand.
Now,
Today there are 2 or 3 things.
one more thing I would like to add.
Yes.
For the academic year, the students were admitted 2021.
Yes.
The Honorable Division Bench has given a specific instructions.
Yes.
The students in their admissions should be informed that their admission is on the basis of this order which has been passed on 16th of September 2020.
Correct.
But the students has not been informed. Students has not been informed.
Did you take any immediate steps against that non-compliance?
Even now, non-compliance, we have been asking for that. They have not come up. Even the ministry have, what ministry has said, I'll come to that report. Little bit time.
So now today, what is the scenario? What to be done? Now the question is again, I'm
Yes.
saying,
Yes.
I tell you very frankly, the entire issue appears to have been digressed or diverted from one stand to another stand.
It is not the university. This is the 10, 13 applications have been filed.
I told you the issue. I never said, no, I never said at the behest of the university or at the behest of anyone.
Demonstrate before this court that
Now-
they have
now the
fulfilled
question-
single condition.
Correct. Now the question is, when this order was passed and it was not interfered with,
It was not.
you might have, I have a genuine belief
Yes, ma'am.
in you that before the division bench, you must have demonstrated that they have not complied a single condition which was imposed.
I have raised that this order has been sought.
Aha, I understand. Yet the division bench did not.
Division it over.
Yes, I am telling you, that's why I'm saying,
Yes,
division bench did not set aside that order
Yes.
or did not observe that this academic, the admission in the academic year is absolutely illegal.
Right.
Absolutely illegal, did not say so.
Right.
This division bench says that the students, as you said, a student must be informed, well informed, that their admission is subject to the result of this. And according to you, they were not informed.
They were not.
I do not know whether it comes in the record or it does not come in the record. I do not know whether they were informed or not.
The report filed by the
But the
ministry
question is that this academic session continued
continued.
because the writ petition or the appeal has not been disposed of as yet.
Right.
Now today where we stand,
Right.
what the single bench said,
The writ petition is disposed of, they filed the appeal is the matter which is.
disposed of in what sense? The writ petition was disposed of granting the entire relief.
Yes.
Entirely altogether different. What has not been asked by them? What has not been asked by them? Their prayer in the application is that they should be granted
Application means the writ petition or?
Writ petition.
Yes,
That they should be granted affiliation without conditions.
correct.
And the relief which has been granted
Yes.
is not there in the prayer.
No, what relief has been granted?
Yes, my lord.
That's why we have not come to about. Actually, the crux of the matter is here.
I am coming.
It is really traveling on the periphery.
If you last give me just 10 minutes,
That is what I'm giving you. You asked for 5 minutes, we gave you, we wanted. What was actual scenario? What the trial court held? I mean,
thereafter, after the division bench, they have filed a contempt application. In the contempt application, university has informed, look, these are the problems, conditions of affiliation has not been fulfilled, and they have got only a MOU. There is no, because diploma courses here, they say we have got affiliation through a memorandum of understanding with the Maharashtra State Technical Education Board.
oh,
We raised the issue. Look, Maharashtra State Board of Technical Education cannot have run the affiliation to your diploma courses. Because why we have to raise this issue? Because diploma courses students, they are taking admission in the VTech under the lateral entry.
what?
They are admitted in the courses, VTech courses.
Diploma course is a different course.
See, after passing the diploma, they are
And they are not coming through that channel of the competitive examinations.
no, based on the diploma issued by the Maharashtra State Board of Technical Education,
Yes.
the students are admitted in the BTech courses running by the Pondicherry University under the lateral entry. Under the lateral entry in the second year.
Lateral entry into the second year.
Second year, they are admitted.
Okay.
This was an issue.
Yes.
He asked, kindly provide us the affiliation certificate. Inspection committee has come here. Inspection committees inspected on 5th of November 2020. We submitted the report before this honorable court. Look, they have got the affiliation from MOU. This is what they say. But there is no affiliation. Courses are not affiliated to MOU through affiliation certificates for the courses at all. We asked them not to admit to the students and later on.
No, then another question arises. Please answer me because that is what is going in my mind. Is there any, the rule or the statutory provisions that if a person has done a diploma course, then your university rules or something permits that they can be immediately admitted into a second semester or a second year? There is. Oh. So that was there.
Objection was only
They can be admitted.
they can be admitted. But their diploma is from MSBT. That was the only objection.
Then that is what I mean. The rule, does it specify that the diploma should be done under your university, then only?
From any university, they can
So
do.
there is no problem in that. But only thing is, only thing is the name of affiliation.
Yes,
It is not an affiliation. It's not an affiliation that there is no affiliation. It is a mode of affiliation. According to you, by virtue of an MOU, you can't seek affiliation. There is no dispute that there is no affiliation. But the only thing is mode, the manner in which the affiliation is named. According to you, MOU does not create any genuine or legal affiliation.
Unless the affiliation certificate is issued under the MSBT Act. And now, after the inspection, the team came here for inspection, they inspect it. And Country University, they have categorically mentioned no later entry admission is allowed as the polytechnic courses are not affiliated to MSBTE. Only an MOU exists, nothing else.
MSBTE is this.
Maharashtra State Board of Technical Education. Technical Education. So MSBT has got a jurisdiction. Their act itself says within the state of Maharashtra only. Now, very recently they have come in the report that MSBT has amended it. They can give affiliation to any college, anywhere in the country or anywhere in any part of the world also. This is what they have done. It reminds me of one judgment of Professor Yaspal versus state of Jharkhand. Where the state of Jharkhand has passed an act. They said the university can have off-campus anywhere throughout in India. As a result, a lot of universities has come up. Professor Yaspal had to go to the Supreme Court by filing a appeal application. And the Supreme Honorable Apex Court said, under Article 247 of the Constitution, it is the Parliament which can frame rules for the entire country or a part of the India. But the state government can only frame rules for the state only. So that was set aside. Now they have said, and this amendment also, it is prospective. And they are running this college from 2003 onwards. Now, after 2003, where after filing of this applications, they have only disclosed the first MOU which had been signed by them in 2003. No, subsequently they say we have signed a MOU in 2018, 26th of November. The university asked the question, what about the in-between period? That too, when one of the MOU was produced by the industry, which was signed on 8th of February. Now they say they have filed 5 memorandum of understanding, but on record there are only 2. Now the question why the university is bothered? What has happened very recently, my lord? When the JNRM, one of the college here, Jawaharlal Nehru Rajkiya Mahavidyalaya, when it was transferred to Pondicherry University from Punjab University.
Hmm.
The degree course was for 2 years.
Hmm.
And they did the degree course. After the degree course, they were supposed to do their bridge course. But without doing the bridge course, they have admitted in the postgraduate degrees, and they were admitted. They obtained the MA degree, they further higher degrees. They were appointed as principals. Many of them were promoted as PGT on the basis of the degree.
Hmm.
By filing a appeal application, their appointment was challenged after 25 years.
Hmm.
That they have got invalid degree because the admission which has been obtained in the post-graduation without doing the bridge course is invalid.
Absolutely.
So they went up to Supreme Court. Finally, they got a relief in their favor only on the grounds because they have not committed any fraud. They have done the courses. They have been working for a long time. This judgment was passed by this matter was happened by the Supreme Court SLP. This is the case. This is the one reason why Pondicherry University was more particular as to these students who have passed a diploma from MSPT should not be admitted in the BTech course. Otherwise, there was no reason.
I do not know what the amendment says because I have not been there.
Malaj, may I submit this? My learned friend is going on for quite some time, Malaj. May I submit this to cut short the matter? There were the court at some point of time taking into account the exigencies of the situation, especially the uniqueness of Andamans and the constraints on it, as well as the demands of the Pondicherry University, asked the union MHRD, to which being a central university, Pondicherry is also affiliated, and as well as we are also working under it. So it asked them to submit 2 reports and to go into it and submit a report. Malaj, that report is before the court. And that's what I was saying, Malaj. It has given us some time to comply with this separation of diploma and degree. But in any case, Malaj, I am being assured at the highest levels and will record my submission that we are going to have a deemed university of all the universities of the islands, because maybe the conditions which are being imposed may not be feasible to be fulfilled. And the new education policy has also come into effect, which will recalibrate everything. But we'll take this into account. All we are saying at the present moment, there has been no admission. This court has been pleased to grant that there will be no further admission. So whatever admission has happened, examinations have happened. Let those students, those examination results be published. And my lords, hopefully by this end of this month or end of next month, my learned friends may not have reason to complain at all. Maybe we will all part on amicable terms. But I'm not giving a specific date because, my lords, I don't want it to be.
I was going to ask you this, that can we record any timeline in between?
I'm sorry, Malaj. I'm sorry, Malaj.
You said that the Ministry of Home Affairs is contemplating to resolve this impasse by taking a informed decision, as you said, that in the island there should be a deemed university. No difficulty. Can we take it any timeline within which it can be done?
Malaj, I've been assured a very short timeline.
Very short time.
Very short timeline. I don't want to commit to a timeline because I know, but I'll be very short. It's on the cards. It's a high process. It will happen anytime, but I don't want to commit to a time because I know if once it's recorded by the court that it has its own repercussions. But I've been assured at the highest level that it is going to be very short.
Okay.
In fact, I was surprised at how far advanced it is. That's all that I would say, Malaj. I don't want to commit to a date because, tomorrow I don't want to be in a position where I'll be confronted by saying that.
We appreciate your constraint in this regard because you have nothing to play in this regard. Only thing is you are the creator of instructions. So definitely no difficulty. We can proceed on that basis.
But my lords, will at least this assurance is there that this will happen very, very soon.
No, we will record that. There is no difficulty. We'll record that. Yes.
Now, my lord.
Now what do you want? Now you want. No, don't say so.
We have filed two CAN applications, CAN 9 and CAN 10. CAN 9 has been filed for initiation of the proceedings under section 344 of the CRPC. And the second application is that they have obtained all the orders
By fraud.
by fraud. Why do I say so? If you look, your lordship, look at the fraud.
My question is that if that applications have come, I do not know whether they were given an opportunity to deal with that or not.
We have served the copy, their applications are there, they are mentioned.
No. Applications are there, whether they have been given an opportunity to respond or not to respond.
Let them respond on that.
So that is what.
May I make a humble submission?
Just 1 minute, they have to respond.
Right.
So if that is the position now, for this purpose, now for interim purpose here. Now, question is that what is to be done?
My
So in that, the report has come, the report has come.
report has come,
There has been an order, there has been an order for 2020, 2021. The deemed affiliation is there. I mean, affiliation by a judicial order. Let us go, be very politically correct. Yes, in this regard. Affiliation through a judicial order. This order remains. The admission has already been done. The courses are being pursued. May not be in tune with what you wanted, that it should be conducted. May not be. There is no difficulty, but it has been. Now there has been an examination conducted by you. The papers are set by you. The examinees are determined by you, selected by you. The result has to be the answers are being evaluated by you.
the result, as far as the result is concerned, we will declare subject to the outcome of the survey application.
This is what I was thinking.
What is
This
the
is what I was thinking.
application for September 21st of September? If you read.
Correct.
So it takes some time. My lord, my point is,
Yes.
if your lordship looked at the orders of 16th September 2020, just for a moment, page 358, what has been? It is also the stand taken by the representations in this application 1077/2020 that the DBRAT has complied with all the requirements of grant of affiliation for the academic session 2019-20, as also the subsequent academic session 2020-20.
Correct.
Now, this order was passed on 16th September 2020.
Good.
They have stated before this court that we have complied with all the conditions. Now, they say for complying with the conditions, we require two years more time. Another important thing is, this honorable court has passed two orders. As to why, first order, they have directed the university to grant affiliation. Subsequently, by another order, they say, ministry says, we have got no authority to grant the affiliation. It is the university which has to grant the affiliation. When these two orders were brought into the notice of the earlier division bench said that the joint secretary or additional secretary could be present in the court to assist this court. Nobody turned up. Then finally, whenever arrest warrant was issued, they came here and no affidavit was filed. No clarification is issued even till date. My point is this matter pertains to an educational institute. I can take your lordship judgment orders also.
Malats, I will only say this, my learned friend is going on. Malats, at the present moment, a lot of water has flown underneath it. My learned friend is agitating the issue.
No. Please, just bear with me for a moment. Now, the position as it stands today is, because there are several applications which are also pending in this particular appeal. They must respond to those applications. We cannot continue and dispose of the requisition as it stands now. As it stands now. The question is, when the matter has come up, what it should be the interim order which the court at this juncture must pass, just to safeguard the interest of all the litigating parties. Now, question is, what the court is supposed to do? Now the report was sought for from the Union of India. The report is on record, and they have annexed certain, they have said certain things which has happened or likely to happen. Both ways. Now, in this perspective, considering the plight of those children, which is still at large, what should be the best course which should be adopted by the court at this time? Now, what we feel is, obviously, you have a lot of grievances. You have raised a question that you can't have an affiliation with another state university or a state board of technical education when you have an affiliation with me as a Pondicherry University.
No,
You said,
affiliation with other board.
no, you. That was that problem. Secondly, when you find that there cannot be any legal impediment in this regard, then in that event, the affiliation which they seek or which they claim to claim with the another university now, then you raise an issue that this is not in consonance with the statutory provisions which are applicable thereto. You wanted to say that, look, this is a state-based act. The state list, there is an entry in the state list on the basis whereof legislative competence has been provided to them. They cannot travel beyond that. Definitely, it's a question of Article 245 is to be considered. The extraterritorial operation of a particular act.
Right.
That is whether it comes within the occupied the concept of a doctrine of occupied field. It will come under the concept of doctrine of pickle substance. All these have to be gone into, at least when you raise this issue. These are the very larger issue one has to ponder upon, whether it can go, it cannot go. At this juncture, it is not possible to go into these aspects. Question is, if the affiliating body, means the Maharashtra, if they have not raised any objection regarding the affiliation till now, if I consider they are not. The question is that if they recognize that these are the affiliated college under me, then on a lateral way of admission, as you said, you have a grievance on that it is not in consonance or tune with my act, my conditions. These are the larger issue to be gone into. And when the amendment has now come, whether the amendment will take effect prospectively or retrospectively, it all depends upon the intention of the legislatures that there are two ways. One is an express way of putting particular act to operate retrospectively, and there is another implied way of putting the particular act retrospectively. It all depends upon the intention, the nature, the purpose for which this amendment has been brought. So this is how is again a larger issue to be gone into, and very deep way of thinking should come. We are saying that it does not contain that express word, that it will not operate retrospectively, or it shall operate prospectively. That does not mean, means if there is an express word, no difficulty. If it is absent, then what should be the nature of that amendment? To operate retrospectively or to prospectively? As we know, when this 2002 Act was amended, CPC, 2000 by amending Act of 2000, CPC was amended. Several provisions, they does not say that it is operate prospectively or retrospectively. The court have interpreted it that what is the nature of this statute? Depending upon the nature of the statute, the court has said that it should operate prospectively or retrospectively. And the court has held retrospectively. There is no difficulty in this regard, though there was no express, like a binary transaction and prohibition. The Supreme Court at one point of time in Methodist College says that it will operate retrospectively. But subsequently, the larger bench, considering the object and the purpose of the act, said that no, it will invite a disastrous result if it is operated, should operate retrospectively. No, it should be prospectively. The first and foremost reason was because in that Prohibition Act of 88, there was a criminal, the liability which was attached. And the thing which was correctly done at one point of time gets illegal. For that, a person has to be prosecuted. The Supreme Court says can't, should not. It should operate prospectively. This is all intention, and the legislature's the object and purpose has to be gone into. These are all very larger question. I tell you very frankly.
Right.
It can't be said in one word
Right.
that it is a prospective in nature, unless there is an express indication in the act itself that it will come in force or it will operate prospectively henceforth, or whatever the reasons are. These are the larger issue. Now, today, what we say, we will accept this report. The ministry has sought for time to ponder upon the things, to look up the things, let them do something. In the meantime, since you have also come very fairly that we do not want to jeopardize the academic career of these students who have already been done, we have no problem. The examination has been conducted. We will publish the result. There is no difficulty. We are simply directing in this fashion. Let them come. Let them give a further report indicating the progress which has been done in the meantime in relation to this. And we'll say that since the examination has been conducted and ended very recently, obviously you need time to evaluate the answer scripts. And there is no fetter on your part to declare the results also, as is being done in case of other affiliated in colleges.
Here the problem is, what is the problem? That the
Yes. That's all.
So, my lord, if the interim order is to be passed in this regard, very recently Supreme Court has deprecated this practice.
What?
That interim order is being passed for way of admissions. I just read it out.
No, it's not a question of admission. It's a.
For the declare of result.
That is what we said about anything now, as of now, because we want to wait for some time.
My lord, only in this regard, for some time.
We are not saying, because we have heard the learned ASG, we could perceive the heart notes and the tune in which he has set his rhythm. So I think let us wait for some time.
My problem is that single-handedly I am facing all this.
What?
This case.
Really? Nothing. We are here.
Yes. That's why I'm making my submission, my lord. The ministry has filed the report.
Correct.
In the para 12,
Yes.
the college says that we will complete this affiliation,
Hmm.
this all the conditions within 4 months.
Correct.
Right.
No, para 12 is not here.
Para 12,
The report contains only 9 paragraphs.
which paragraph?
Today, the report has come, it contains only 9 paragraphs.
The report is after the affidavit, the first annexure.
Yes,
That is the affidavit. After that, the first annexure is the report. Yes,
this
yes.
is what we are looking at.
Yes,
9
that-
pages of the affidavit.
Affidavit.
Thereafter.
Oh, sorry, yes. Thereafter, which page, running page?
No running page.
Bottom of the page it is there.
Running page what?
At the
Annexure A1 or A2 or what?
It's the annexure R. It says annexure R.
Yes, well, annexure.
The first annexure R.
No, annexure A2 I could get.
No,
Just after that.
after the.
Annexure R, at page 19,
Annexure. Yes.
at page 19.
Report in the matter of affiliation
Yes,
of
yes,
Dr. B.R.
yes.
Ambedkar Institute of Technology.
Yes, you are referring paragraph
First, paragraph 3.
3.
On 12th December 2022, the Honorable High Court passed a direction upon the Union of India Ministry of Education as there were 2 letters, both issued by the Union of India Ministry of Education. One is of 28th October 2014 and other one was 12th of October 2021. Both the letters are not in harmony with each other, and the direction was given to the ministry to clarify the same from the office of the rank of the Joint Secretary from the Ministry of Education. Now, in this report, there is no clarification about these 2 letters. Another point which I wanted to make before you.
If this stays up, then you take an.
That's my learned friend is agitating the same issue.
To the report. You have not taken an exception.
I'll do.
That cannot be done this way. Then try to. Yes. So if there is any discrepancy, if there is anything which has been consciously made with the falsity, no difficulty, take an exception and highlight or we'll consider that.
Why waste the court time on this?
Unnecessarily, why should we at this stage? No difficulty.
Why?
Consider that children, I appreciate we appreciate your stand.
Why not?
Very clearly you have said.
College
Schedule.
must have the teachers. They don't have the teachers. They don't have the labs.
Now, the question would be that whether. Correct. Only thing is, second thing, which is playing in my mind, I must say, my sister judge will also follow me, I do not know. So what is playing in my mind? Actually, the examinations are conducted by you.
Also is okay.
The question papers are sent by you.
Why not?
You are conducting this examination pan-India with all the colleges who have been affiliated with you, I believe so.
No, it's
Same for a semester year, same set of papers are prepared. Not for different, for other parts of the country different. I don't think so.
No, because
There is a uniformity in the.
the kind of petition that their examinations are not being conducted. Why they have
Examination paper, pan-India, has to be one paper. Has to be one paper, pan-India, can't be. So only thing is the faculty as you want it should be. So then I think the evaluation of the students have to be judged in that parameter. If they have shown a better result than another college under your affiliation, having a full-fledged faculty like you, as you demanded or wanted, I think you should ponder upon twice. If the students are so bright.
I am grateful.
already the honorable division has passed an order for the minimum standard that I will change, my lord. At least.
No, I'm probably you could not get me
No,
what you wanted to say.
As far as the result is concerned,
You could not get it what I said.
I'm not.
Take time to find out.
Immediately, how to take this come up?
Now look at the situation where there is only one teacher in the school. And he teaches all the subjects. Hypothetical example. There are many I can give you. One teacher who teaches all the subjects. At my time, in your time also, in class 4, there was a board examination.
Yes.
I also appeared for the board examination. I do not know whether you must have.
Yes.
Because I am much after, came in the earth much after you. So definitely, it so happened in a school, very small school, one teacher. All the students, they stood first. Whereas another school which has a multiple faculty teachers teaching English separately, mathematics separately, the other curriculum separately, they could not come up so well.
Singh knows that. Mr. Singh knows that.
One school. So it all depends how the students are taught. So at this juncture, definitely, I know there is a rule that should be followed, but we'll consider later on, not on that. Evaluate.
My lord, 1 minute time for me.
Your clients are here.
Yes, sir.
So then you should open your mouth to justify what you expect from them.
My lord, I filed this CAN application.
So we are taking out your purpose is served because he has also candidly said results to be declared.
Examination was conducted in the month of July. For
So it
other,
was say 21st of September, it may so happen.
for other colleges, results already declared.
Which one? So we will say that if they say that 21st of September, that's a very recent.
My lord.
The examination is over, last paper was there. So definitely for evaluation, what do you think? Computer? No.
No, my lord, it is already done.
No, it's not done.
For
It
other
says
colleges,
21st,
close the question. Order.
24th, they will declare without any unreasonable delay.
Declare the
Yes,
result.
come on.
My lord, they should declare the result, they should issue the mark sheet, they should issue this provisional,
What now?
provisional certificate also.
And embrace them also individually, who has passed out. That relief you have not called for, you have not paid for. Call them on a dais, embrace them and give them individually. That will do?
My lord.
Oh, happy.
Yes.
Embracing means what? May I say in Hindi so that you will understand? Gale lagana.
I understood, my lord.
So every student will be called, they will be embraced and then given result. You want that really?
My lord.
So they will give you everything.
Ultimate victims are the students.
Sorry. Yes. This is the report you have submitted now, Mr. NG.
My lords, it's been submitted by the MHRD. My lords, I appear on behalf of the administration, but it's been submitted by the.
This is today you have submitted.
Long back.
Achha. And this was pursuant to order.
15th of February.
It's at the first page, Lord. 15 February 2023.
And thereafter, many orders have been passed.
Yes, yes.
So they definitely. took
Actually,
note
my
of-
lord, the court, the division bench wanted the matter to be settled for once and for all. That is why they passed that order.
we are recording this order in a more broader way instead of going into the nuances of each of the orders. The matter was mentioned before us, citing an urgency that the career of sizable number of the students who are pursuing their courses with the debrate, I do not know how it pronounced, debrate. Is in dualdom because of non-disclosure of because of non-publication of the results of the examinations conducted recently. Conducted recently. The dispute as unfurled pertains to the affiliation with the appellant number 1 of the said technical college, that is debate, as several lapses and the violation of the conditions of affiliations were noticed during the joint inspection. And according to the appellant number 1, those lapses as noticed by the inspecting team have not been rectified and not redressed as yet. Mr. Singh, the counsel for the appellant number 1, says that the university was sensitive about the future career of the students pursuing their study in the said technical college, and even noticing the deficiency and or lack of adequate measures having taken in remedying the same under the rules of the university, yet the provisional the affiliation was granted from time to time with the profound hope that the said technical college would adhere the requisitions as indicated in several letters. However, his client is disappointed as the college have not taken any adequate measures as on date. All of it has not taken any measure, and the writ which was filed by the said technical college
And
along with the administration, resulting into the impugned order, needs interference in the instant mandamus appeal. The appearing party, the college, the technical college as well as the administration are unison in their stand that all steps have been taken, and in fact, the progress was being made known to the appellant number 1 from time to time. So it further appears that several orders were passed in the writ petition directing the affiliations to be extended for the next academic session, and one of such order was under challenge was challenged by the respondent number 1, appellant number 1 before this court, before the division bench of this court. So the division bench, however, did not interfere with the order, but made a categorical observation that the admission in the said school in the said session shall be subject to the result of the writ petition, and the students must be made aware of the order of the court, and also kept all the points agitated by Mr. Singh before the single bench as well as the division bench to be kept open, and if taken at the time of the hearing shall be decided by the single bench. Be that as it may, the single bench has finally decided the writ petition, and the matter, the instant mandamus appeal is pending. So the learned ASG is the learned ASG considerately submit that he has received an instruction from the Ministry of Home Affairs. Home Affairs, Mr. Minister of Home Affairs, that
Well, it's,
yes, what?
Malats will record from the administration. We'll record from the administration. It's rather than from the Ministry of Home Affairs. I've spoken to, but I don't want to take name of any specific ministry. Well, it's from the administration. We'll record my submission and on behalf of the administration.
London ASG considerately submits that he has received instruction from the competent authorities. May I be very vague on that? Competent authorities.
Yes.
That the impasse creating, creating the stake of the several students uncertain shall be resolved in near future, and an adequate decision shall be taken in this regard, so that the colleges established in the island cannot face any such litigations which would hamper their career. There is no specific time, there is no, though he is not in a position to calculate any specific timeline within which such measures would be taken, yet the term which he set at the time of an argument inculcate a sense that the administration as well as the other competent authorities are serious in taking up prompt decisions, showing alacrity to the situation that has arisen in respect of the said college, technical college, that is debate. Be that as it may, the concerned hovers around the fate of those children who were permitted to sit in the examinations, but the result has not been published as yet. Mr. Singh, the learned advocate for the university, clearly submits that once the examination has been conducted, there cannot be any apprehension in the mind of the students that the result would not be published. He assured the court that he further submits that the examination was with the examination for a particular academic session ended recently. He said 21st of September. You can't put your. Sorry, if he has said that 21st of September, then you can't put your words because I'm recording his submission.
Professor is present in the book.
No, whatever. That is your submission. How can he put his words in your mouth? Recently, more particularly on 21st September 2023, and therefore a reasonable time shall be taken not only for evaluation of the answer scripts but preparation of the results. And therefore, if any timeline is given in this regard, it may have some counter effect on the role of the university in relation to other affiliated colleges. The stand of Mr. Singh is seriously disputed by the Students' Union, Students' Council. According to him, the picture which was sent indicates that the examination ended in the month of July 2023, and therefore there is no input there, and therefore the stand of the university does not appear to be fair and reasonable. It is further submitted that the result of the other colleges affiliated with the same university had been declared. And therefore, the said council do not see any reason in delayed declaration of the result. Be that as it may, we do not intend to go into the nuances of such stands taken before us. The university has conducted the examinations and as fairly submitted, would declare the result on evaluation of the answer scripts of each of such students. Since the university has shown its fairness in taking all the adequate measures, we therefore feel that the university would declare the results of such examinations within a reasonable time, showing an alacrity to a situation, and also bearing in mind that the academic career of the students does not hamper. We have been it has been brought to our notice that when 10 and 11, what you said,
9 and 10.
when 9 and 10 has been taken out by the applicant number 1, raising a serious questions relating to a wrongful disclosure of the fact in order to achieve the sinister purpose and a further appropriate directions to be passed. So, since the serious allegations have been made by the applicant number 1 in the aforesaid application, we feel that an opportunity should be given to the respondent authorities to respond to such allegations. Accordingly, they are permitted to file appellant opposition to the aforesaid applications within 4 weeks from date. Reply, if any, shall be filed within 2 weeks thereafter. Those applications shall be heard along with them with the instant appeal. Since let this matter be posted before the next circuit bench, when the administration and the other competent authority would submit a report indicating the progress having made in the meantime. This is what is accepted, part of the record. It has been filed earlier, many orders are passed thereupon. We have also indicated.
My lord, small correction is required. The examinations were conducted on 1st of September. Concluded.
21st instead of 21st first.
And the results would be subject to the outcome of the MA appeal.
You first record.
Because the earlier ones are like that. Earlier
Same result.
Fine.
Why they will not issue a certificate? I do not find any reason. Don't worry, we have kept the appeal pending. Don't worry. No difficulty. Don't worry. If they do not come, make an application, we'll consider. We have said that they will declare the result. Which one they will these are the no, they don't give it. Have you not given?
Well, subject to the outcome of the MA, we have given. Subject to the outcome of
They will do it in the same way.
University, the problem is facing.
Last year, have they not issued a certificate?
Subject to the outcome of.
Have you not issued a certificate?
I'll just find.
Issued. No, issued. Now come. said issued.
Candidate certificates are rendered.
Just
check up, my lord.
you check up, give a report, then they will come an application with 10 against you.
No, no, they come again. They will come again.
That's why I say, please confirm from your officer, we will record, that is the conscious decision that you issue.
Final year students will not original certificate is not going to be issued. Otherwise, it is very.
After the declaration of result, the provisional certificate shall be issued to each of the successful candidates. Why not? And the final certificate shall be issued upon the disposal of the instant appeal. Right. Provisional.
Mark sheets.
Which one?
That will come.
First thing is, they will provide the application filed by each of the candidates for sitting in the examination. They will also provide the numbers which each candidate obtained in each of the subjects. They will provide the mark sheet of each the candidates showing whether they are successful or unsuccessful. They will supply the admit card also of the examination, permitting them to sit in the examination. They will also supply.
Admit card already issued, only then they have appeared in the examination.
I thought it's joking.
Acha, acha. My lord. I'm sorry.
Why not the center where you sit in the examination?
Mark sheet is very much required.
Sir, the provisional certificate means the mark sheet will be there.
Final year students will not.
Yes, everything, sure. Now the trend has become that everything is done with the precision and the clarity. Can it be?
He appeared examination.
Why no, it is not expected. It is not expected. We have not gone into this. Otherwise, we have to record that he said the certificate for last year has already been supplied and issued to all. Then,
I will do each and everything, whatever they are asking for, as far as the students are concerned. But they should bother about that 2019-20 has been affiliation has been set aside by the learning single judge.
yes,
That affiliation has gone until unless the appeal is not heard. That's why it has been subject to the MA application.
this has consumed more than 1.5 hours.
I know that. I'm grateful. My lord.
Round and round. Same thing, round and round. Wasting the footstep.
Who has created? Who has created? Who is responsible?
You have, your department has.
Demonstrate.
Constitution does not have the provision like a postmortem in a criminal law. So order is passed, matter is over.
I know. I'm grateful.
Yes, thank you.
Right.
Thank you.
There's a direction to file report, my lords. You have prepared the report. I'm just submitting the report, my lords. Actually, the original is on its way. This is North and Middle Andaman, but we have received the Xerox copy, my lords. I'm giving, for the time being, I'm giving the Xerox copy of the report. Photocopy as well.
We have 5 reports of the department.
Come down for your lordships, my lord.
My lord, as per the direction, I have 5.
I'm giving him. So the photocopy, my lords, I have given, that is coming from North and Middle Andaman, so it original hasn't reached, but I have given the photocopy.
Mr. Govind, one thing I do not know here, I find a very unique procedures being adopted by all of you. When an affidavit is sought by the court, then the court never expects that what relief you wanted from the court.
Yeah,
the court simply want the narration of the facts, the disclosure of the important facts, nothing more than that. The relief what the court will grant, that depends upon that particular fact. Hence, I have seen in many of the reports, every report affidavit when it is sought contains a prayer. How? We never come across, in my career over here, for nearly 19 and a half years, we never come across with this kind of an affidavit. Not expected in the principal seat. Here also, only, we find that every affidavit disclosing the fact contains a prayer. Should not. You know what? Pass an order. Whatever we wanted to do, pass an order. That does not mean. Yes. No, that is what we wanted, that you should highlight the exact state of affairs. Nothing more than that. We wanted you to do that. Yes.
Because we have also submitted a report, my lord. The original is on its way, so I have submitted photocopy. Yes.
There are a number of cases, these motor accident claim cases and all, everything has been disclosed in this between 7/8/2023.
No.
Sorry.
I had cases on that particular day. As I mentioned, I was coming back from Hon'ble on that particular day.
Anyhow, yes.
The report, my lords, we have submitted. So,
Immediate report is also valid.
Yes. 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 What is your stand?
My lord, I have just received a copy, my lord. I couldn't even go through the report.
I have seen that. After that, I reacted and asked him what to do.
Soul of this case, my lord, is from day one.
I have seen from shirking the responsibility from one shoulder to another. This is what I have seen. I gathered from. Now, how to create a bridge. This is what has to be done. Now, both have to work in tandem. So, what should be the factor? Because they say they wanted that you have I think constructed or laid a Hume pipeline,
Yes.
as they say.
No, but that is very surprising. On that day, the officer concerned has mentioned that as if the Bailey Bridge was causing the obstruction, but we came to know that he was not aware that a concrete bridge has been constructed.
No.
No, my lord, in the
My lord,
span of
see-
20, Lordship will kindly consider
Now,
my report
now
for
the
once.
question is the Hume bridge, Hume pipeline.
Pipelines.
Now, they say that when lot of, the foul water that comes, and it contains with lot of, the garbages or debris. So that really choked the pipeline. Sometimes it so happened.
Yes.
And
that-
then there
that
is definitely when there is no outlet being given, free outlet or
It's pushed back.
it goes back. It goes, no difficulty.
Yes.
Now the question is, they wanted to have the removal.
Yes.
Now you'll have to find out how it is to be laid.
No, my lord,
No, no,
kindly
my lord,
consider
just-
my report.
one
My lord, in my
second.
report, I've
Second
indicated.
is, so long it is not done. What is your role? Two things they have highlighted. First thing is periodical cleaning of that particular pipes. That is your job. Second is they wanted a creation of a drain system along with the national highway.
Yes.
So now that has to be done. Now the land is of a national highway. I think apart from the road, they own the land in a culvert as well.
15 meters.
It's a 15 meters.
It
They
depends, my
call
lord.
it I do not know what the right of way, ROW, right of way. So I was doing one arbitration regarding that. I was just recollecting that. Right of way. So that is there. This has to be put there. So it's an obligation of the National Highway Authority. They will put a drainage system, but you have to provide all these, the permission and the infrastructures to them. And the cleaning purpose must be done by you.
Lordship,
In fact, my lords will.
my report for once.
No, no, in fact, my lords will see this report is not, my lords with the great, this is not, my lords, we have taken it upon ourselves also, my lords will see, we
We
have.
have seen that, but now the
Check.
problem is you are there to maintain the National Highway.
No, he's,
But so far as
I am admin, APWD, he is.
I was talking, I was not NHAI.
No, no.
So I have seen
He is
that report.
Yes.
This is.
So there is no difficulty.
No, my lord, kindly consider, my lord, that portion we have indicated, there has been, my lord, in a span of 20 kilometers, but there has been, my lord, 94 water outlets, pipes. Some, and my lord, we have indicated that some, my lord, the width of the pipe has also been increased. Considering the, my lord, what has fallen from your lordships, that sometimes due to this garbage and other dirt being accumulated, the free flow of water is sometimes it becomes
You
stagnant.
create a proper drainage system
That has been done.
along the National Highway,
Yes,
create a proper, and then we will direct the administration to take care of that.
lordship, my lord,
Cleaning and
what happens is, my lord, in certain portion, the drain is there. In certain portion, the water.
you have to create, because in this portion, they have indicated there is no drain.
My lord,
Only the Hume pipes you have created, which really clear the water and acts as a sewerage line. So you have to create a drain, proper drain along the side of the National Highway. And secondly,
This debris has to be removed by the administration and them together, APWD.
so that is why first thing is that's your duty to remove the debris.
my lord, may I suggest one thing subject to, my lord, the convenience of our learned friends, my lord. Lordship, let us all, because, my lord, today, right now, I have received both the affidavits. My lord, if your lordship, my lord, takes it up tomorrow, my lord, once. Now, my lord, we can come down because there are certain portions. I don't say that something negative has been stated or mentioned.
they have not.
But the fact remains is, if, my lord, because our instructions, which I have received at the very outset, that the entire stage doesn't require a drainage, because that comes from an expert's opinion, my lord, who has taken stock of the situation. Now, my lord, definitely after the visits and after the joint inspections, the opinions can change. There has been certain reflections in the report. Now, my lord, let us all, my lord, let the administration also consider my report. Let learned officers also consider my
The
report.
parties are directed to exchange the report submitted in terms of an order dated September 9, 2023. So the appearing parties are directed to take necessary instructions, more particularly the National Highway authorities, on the the concerns shown in the report submitted by the administration as well as the affidavit filed by a practicing advocate of this court. List the matter tomorrow in the same position.
Grateful. My lord, I have already supplied my copies to learned special officer.
If you have not, do it, circulate amongst themselves. Let them, everybody come up. Let's call the.
Yes, Mr. Tabriz is appearing now for the other side, my lords. He had to go to the mainland because his wife is unwell.
Next circuit,
It can,
since Mr. Tabriz appearing for the respondent is not in the island for his personal reasons. Come on, let this matter be listed before the next circuit. Next.
I appear for the state, your lordship. It's a bail application.
Who is for the petitioner? Case number
20 B, 27A and 29 of NDPS. The accused is in judicial custody.
what is the quantity
More than 3 kilos.
of,
356
Ganja.
kg of ganja.
and what is the commercial quantity?
More than 20 kgs,
So it is the intermediate quantity,
intermediate.
intermediate quantity. What you were doing with this?
No, I was not arrested. with this.
You have been arrested on the statement of the other
Yes,
co-accused.
yes.
What is the
Who's financing?
Tufan Singh's judgment? What is the Tufan Singh's judgment?
He was financing the,
What is the Tufan Singh's judgment?
Document to that effect.
I am asking you, what is the Tufan Singh's judgment?
Real Chakrabarti judgment. Have the
Of?
Supreme Court. Real Chakrabarti judgment
Of,
of 2020.
of which court?
Hon'ble Supreme Court.
By Justice, by the Chief Justice of India now?
Now, Honorable Justice Sarang V. Kotwal.
He's not a judge of Supreme Court.
no.
I don't know.
But if CD may be called, let us come tomorrow, your lordship. CD is not with me.
Yeah, my lord.
Sir, you are citing a judgment of a Bombay High Court and you say Supreme Court. I was also surprised because I know the Tufan Singh judgment.
Yes.
The recent judgment is of a Nawaz Khan. And it's the Bombay High Court judgment you are citing and saying the Supreme Court.
No, my lord, it has been decided that on the two grounds that the recovery is intermediate quantity and there is no criminal background of it.
No, I understand. I said that there are two aspects of the matter. One is the Tufan Singh. Do you know what the Supreme Court has said in that? It says that the statement of a co-accused in an NDPS case cannot be applied upon another person because he has been arrested on the basis of his disclosure. So the Supreme Court has said that that is not a reliable piece of evidence and therefore the arrest in this regard is not correct.
Lordship,
Because any statement made under section 161 or before the police authorities, that is not a reliable piece of evidence. Under section 27 of the evidence.
Lordship, I
Only exception is to the extent of the recovery. If there is no recovery. Nawaz Khan has gone a bit
further distinguished.
further. So now you read that Nawaz Khan's recent judgment and find out whether you come under the exception or have the case made out a case number. Otherwise you can't.
Lordship,
Let the, when the bill application is moved today, the counsel for the state showed its inability to produce the case diary. So let this matter be listed tomorrow to ensure the state to produce the case diary when the matter would be taken up.
much obliged.
It has already been submitted.
Let the, I don't have the statements of the witnesses.
Investigation has already been completed. Target file.
Come at what stage? come with the judgment of the Chief Justice of India. On this, the charge sheet has been filed. Unreported judgment. Passed during the pandemic. Yes, call the next.
This is that matter, my lords, where this is that matter, my lords, where, my lords, the question was of relaxation, my lords, and my lords had granted me opportunity to come back with that judgment of the division bench. As I am handing over that judgment. Do copy.
Special bench judgment of our High Court.
No, madam, division bench on the issue of, this is that MA B.Ed where my learned seniors, that is 12th pass, and they are saying that because they later on got the JBT, so it should relax for them also. My contention is that it is not discriminatory because the
Says is not a case.
no, I'm not completed my submission. What I'm saying is that the relaxation has been given to this group of people who are MA B.Ed having high qualification, so they are treated as a class. So therefore, the power to relax is exercised in their case and is not exercised in case of
JBT.
in case of this person who has filed the writ petition.
JBT.
Yes, ma'am. So I'm relying on this judgment on
What
the
it says.
nature of power of relaxation.
Yes.
Here also, mandamus was sought that the power of relaxation should be exercised. An essential criteria should be relaxed.
Happen to be a.
Detailed reasons are given in this
Let us
case.
see. Let us see.
My lords must see the impugned order. Impugned order sets out the contents of the order passed by the administration, whereby the prayer for relaxation was rejected. detailed reasons are given. So my humble submission is power to relax the domain of the employer. If it is a completely arbitrary, that's a separate issue. But here it is not a case of discrimination, because those people in whose favor relaxation was exercised do constitute a class, because they are highly qualified people, and that is the employer has exercised his discretion to say that these 5 people are a class in themselves. So therefore I'll relax in their case. This petitioner is not similarly circumstanced as them, because he's not part of that class. He doesn't, had he had the qualification of MA B.Ed, he could say that you're given for 5 MA B.Ed, you're not giving for me. But he is not part of that class. What he is seeking is relaxation should be separately exercised for him as an individual.
School is up to class 4.
Your Lordship,
Primary school is up to class 4.
class 5,
5.
1 to 5. Now, Your Lordship,
Now the decision,
yes,
Let him come.
let him come.
my submission is, my lords, that it may be right or wrong, but it is not arbitrary is what I'm submitting. So
I got
therefore,
your point.
yes, that is my
So
submission.
let us hear.
Yes.
My only submission is that JBT was the essential qualification.
Where is that?
Your Lordship,
Recruitment, just show us 2-3 things. At the time of advertisement, or there is a rule which says the minimum educational
Yes.
qualification
just,
and the age.
yes.
These 2 things you please show us. They must have indicated
Yes, they have indicated.
where do I get?
Just a minute, Your Lordship. Your Lordship, may kindly come to page number 66. Now, Your Lordship, these were the persons who
No,
were.
I am not talking. Please, I am.
I'm showing that JBT is the essential qualification. First, I'll show that.
No. What they were doing it, they were all of you, including those have been, they have been picked by them to be more suitable for that. You were working on a contractual basis.
Yes. On
And then
contract basis, they have engaged.
there must be some kind of a notification which says that all these contractual employees, they would be absorbed against the sanction post, or they have to undergo with the examination,
Yes, JBT.
process of selection.
Your Lordship,
So
I'll show
have they
that.
notified?
That's what I was showing it, Your
I
Lordship.
wanted that.
But we have to see a little bit say, from the beginning, Your Lordship. Otherwise, it won't be possible.
No, I want that.
Yes, when this is page number 66,
Yeah.
when these persons were engaged during the time of tsunami, Your Lordship,
Yeah.
at that time, the authorities have considered these 8 persons. Kindly come to that, page number 67, these 8 persons were there. These 8 persons included number 1, number 2, number 3. They were JBT. Got it, Your Lordship? Say page number 67.
I got you, yes.
So I need not show that the JBT is the essential qualification. Then I will come to the second part. I'm just showing.
I just wanted, there is what is the bare minimum qualification set for this primary school teachers? I just wanted to know that. I just wanted to know that.
Yes.
You were harping on this fact. I just wanted from which document that shows that the minimum educational qualification for a primary school teacher is a JBT.
Page number 68, paragraph 5.
Sure.
The department has proposed to fill up 118 posts of primary school teachers through direct recruitment, for which notification is going to be issued very shortly.
Yes.
3 JBT qualified candidates may be asked to apply for this recruitment. If they come within the zone of concession, they may be given appointment in the PC.
Now, whether any advertisement for a direct recruitment was done?
Thereafter, Your Lordship.
Yes.
Thereafter, it was not done, Your Lordship. It was done.
Till
These
date?
3 persons were appointed directly. These 3 persons.
These 3 JBT qualified candidates may be asked to apply for his recruitment.
Yes, they have just
If
mentioned
they
about
come
it.
under the zone of consideration, they may be given appointment in PST post.
Just to show that for PST, JBT is the qualified
Correct.
qualification.
Now,
Only to show that.
to us,
Now, thereafter, Your Lordship. Here, because we were engaged as educational helper. That document also I will show. Page number 71.
Yes.
All qualified candidates, that is educational helpers of Kachal Alliance, may be engaged as.
Just 1 minute, I am looking at certain notes.
Yes.
Yes, now, which one? 71.
71, Your Lordship.
Yes.
Now, 71, Your Lordship, may kindly see all qualified candidates.
What is this document?
This is the note sheet of the department.
All
Qualified candidates may be engaged as Sarva Shiksha contract teachers after getting approval for administration as a special case. Then the untrained candidates who have completed +2 degree may be asked to tender their willingness to undergo 2 years JBT training course, for which necessary action is to be instituted to get approval from NCT for enhancement of intake to the tune of 15 to 20 seats for the session 2006-2007. Only to show Your Lordship that JBT is the necessary qualification. Now, kindly come to page number 62.
No, and the candidates who have qualified up to class 10 may be asked to pursue their education of +2 level.
Plus two level.
Class 12 is a very important one.
Yes, +2 plus JBT. These are the two things. JBT is a diploma in education.
Correct.
Now, Your Lordship, may kindly come to page number 62. This contains the list of volunteers working as teachers, where my name appears at serial number 4. This is undisputed.
Serial number?
So, my qualification is wrongly written as BA, but I was 12th class only.
And with JBT.
With JBT. JBT, I got it in 2012. And what my submission is that when you, this decision is practically helping me, where the respondents have said that they don't have any qualified candidates, so they have decided to rewrite the qualification. Here I was there.
Yes, next.
So this is.
So you acquired JBT in 2015.
12. That document is there.
And when they wanted to absorb.
2018, they have appointed these candidates, all 5 candidates.
They were appointed in 2018.
18.
What was the source of appointment? That is the only source of appointment.
Your Lordship, they approached the tribunal. In 2015, they approached the tribunal saying that those persons have been appointed and we, in the tsunami, we have helped these people. Then also they are not appointing. On those grounds they have taken, tribunal is directed to consider them and then they have given appointment to them.
So now they have given appointment to these MABH.
Yes.
And have not given appointment to any other JBT candidates.
Initially they have given 2005, but not in between. In between they have not given.
One document, my lords, may have page 57, the initial advertisement, whereby these volunteers were appointed. Page 57, annexure P4. That will itself show that they were treated differently, because my lords will see serial number 2 is volunteer teacher who possess class 12 pass qualification, which is
serial page number?
Page number 57. Annexure P4.
So many page number here, I am unable to find out.
P4, annexure P4,
P4.
57.
So my lords will see category and amount of consolidated pay. So serial number 2, volunteer teacher who possess class 12 is 4,000 rupees per month. Then volunteer teacher who possess class, this serial 2 is applicable to them because in 2005 they were class 12. Volunteer teacher who possess class 12 with JBT is 4,500, and serial number 5, volunteer teacher who possess BA, B.Ed and MA, B.Ed qualification 5,500 per month. So even when they were working as volunteers, they were treated differently.
Again, I am showing you, Lordship, one more paragraph. Just turn the next page number 59, paragraph 16. Next page. In the same analogy, such of those teachers who are having the requisite qualification of +2 with JBT training qualification should be paid a consolidated remuneration equal to the starting block of the pay scale meant for a primary school teacher, and those who do not have a JBT training qualification should get 500 less. The scale of pay of primary school teacher is. So this to show that JBT was the essential qualification along with class 12.
Just one submission, my lords. I'm sorry, it's going back and forth. Just one last
This
submission.
is
I
what
apologize.
what I find. Now, sometimes the rule of thumb is the important facets of the, because at one point of time, the court must stop.
Yes, my lords. I'll just one small submission with your lordship's permission, that they did not possess JBT qualification.
So what do you think that we do not know?
No,
May I summarize what emerged there from?
no, my lords. I'll stop. Sorry.
Admittedly, in 2005, when their initial engagement was there, they do not have a JBT
Right.
qualification. They acquired the qualification in 2012.
Right.
And then you took an initiative in 2018 or a 17, when you wanted to regularize those persons, and you have created that MEBA, they should be given an opportunity. They should be appointed, giving a relaxation of age, no problem. And you have spared the JBT and others because they do not come under that. You said that you wanted to create a very real classification amongst the same class of the primary school teachers. One having a higher qualification stands on a different position than having a lesser qualification. This is what you say. So the classification is real in nature.
Yes, my lords.
That's the case. Let us see whether this qualification has any kind of a.
This is the decision of the Honorable Supreme Court, Your Lordship, where it has been held that B.Ed qualification is not higher qualification than JBT.
Which paragraph?
Your Lordship, just a minute. डिसीजन का नाम भी नहीं लिखा है तो कुछ सीखो रे पे क्या
I got it at page 44. Yes. That's all.
That's all.
I will dictate it today itself.
उनसा का फाइल
Yes.
Item 5, WPCT 32 of 2023.
Your Lordship, this is a case of no evidence. No evidence to prove that the applicant was anyway involved in the charges that was framed against him. The charges was that he was working as a beat officer of Namunaghar village, and there was felling of tree in Portmore Vrindavan block, and this particular petitioner, he was responsible to take care of the forest, but he was negligent. This was the first charge. Second charge was that there were heavy felling of tree, and this particular petitioner has issued transit passes for the purpose of taking the logs from the reserved forest. These are the allegation. Now, Your Lordship, the witnesses. I'll just show the witnesses directly to show that no evidence. No, I'm to show that no evidence is there. Witnesses have said nothing.
On the ground of perversity.
Perversity, surmises and conjectures. Witnesses have said it might be.
Surmise and conjecture.
It might be their opinion. They have opined certain things. And that opinion has been considered as proof. No documents, even those documents which are placed, they're looking out in the, on the documents itself, your lordship can understand that this is completely different. I don't know from where they've got, they are saying that this is connected to it. That's why I wanted to show that whatever documents are there, I'll show it. That whether those documents really contain any kind of proof against the petitioner. For that, we have to see the documents.
The fact-finding authority now.
Fact-finding authority, yes. No, your lordship, the fact-finding authority has gone beyond the documents, beyond the evidence, and said that this is the thing. Even the Honorable High Court in the first round of litigation observed that there is no more proof. First round.
That was a prima facie finding because it was at the very nebulous.
No, it was not exactly a prima facie finding because the reason is that the Honorable Court has directed the authorities to conduct the inquiry again.
Correct. So at what stage they wanted everything to be done? So they conducted the further inquiry.
No, they have not conducted. Because they have been to the Honorable Supreme Court. Supreme Court has said no fresh departmental proceedings, you finish it off. Whatever the materials are there, on the basis of the materials, you finish it.
Then what remained? Then High Court's observation, what remained?
I'm just placing it that even at one stage, the Honorable High Court has also observed that there is no proof at all.
Not accepted by the Supreme Court.
Supreme Court has practically not set aside the order of the Honorable High Court, modified the order of the High Court.
The High Court has said that the inquiry which has been conducted by you does not create a clear case of misconduct on your part. And then says a de novo inquiry.
Yes.
Supreme Court says no, nothing. That means the Supreme Court was satisfied that the inquiry report or the inquiry which was conducted has certain kind of a.
No, your lordship, because the Honorable Supreme Court has said the order of the High Court is modified. And then said the observation of both the courts should not be taken into consideration by the disciplinary authority. So Supreme Court has not affirmed the order of the Honorable High Court or rejected the order of the Honorable High Court. Nothing.
Anyhow, that is not a case. You say there's a case of no evidence.
No evidence. I am saying no evidence, your lordship. I can show it that it is no evidence is there.
Yes.
No. Your lordship. First one. Charges, may I place the charge, your lordship?
You have been terminated? Major penalty?
Major penalty. That's what, your lordship. Lower employee, forest guard, camp officer, not touched. Forest guard, lowest officer, he has been touched. I'll show that. It'll be very clear. Page 119, this is the article of charge. K. Hamza, forest guard, while functioning as beat officer Namuna Ghar, has failed to prevent the commission of forest offence. 119.
I have not received the annexure.
Your department might have not given me. Yes. It will be there.
Sorry. I apologize.
Yes.
Shri K. Hamza, forest guard, while functioning as beat officer Namuna Ghar, has failed to prevent the commission of forest offence and abetted, connived in the illegal extraction of 26 trees from inside the Portmore Vrindavan Reserve Forest, Block 1, near Namuna Ghar village. The said illegal extract timber, excluding 25 logs, 12.668 count, that is 80.5 disease, was permitted to be removed and transported to different mills and other destinations, either without transit pass or pass the cover of counterfeited, forged fake transit passes after affixing government hammer mark or cog numbers with numbering cog set. The total value of this of timber illegally extracted and removed from the said reserve forest is this. Thus, Shri K. Hamza, forest guard, by his above exhibited lack of integrity, dereliction to duty, lack of devotion to duty, and conduct himself in a manner unbecoming of a public servant, violating provision of Rule 3 of CCS Conduct Rules 1964. Now, Article 2, Your Lordship, Inquiry Authority himself, he has stated not proved. Shri Hamza, forest guard, while functioning as beat officer, yes, he has said that it has not been proved. Then Article 3, K. Hamza, forest guard, while functioning as Namuna Ghar, has issued cause to be issued counterfeited, forged, fake, manipulated transit passes, transportation of illegally extracted logs from the allotted land of Muhammad Khan, as well as from the Portmore Vrindavan Reserved Forest Block 1 to different sawmills. Thus, K. Hamza, forest guard, by his above act, exhibited lack of integrity, dereliction of duty, lack of devotion to duty.
Whether this
To conduct.
forest guard is competent to issue that particular.
No, Your Lordship, it has to be issued by camp officer. I'll show the document is there. The seal of camp officer is there. Now, the reply is very important. In the reply, I have stated that I was appointed as a beat officer of Namuna Ghar. I am not concerned with Portmore Vrindavan Reserved Forest Block. This is a specific reply I have given. Page number 125. Kindly see the third line. Since I have never been entrusted with the charges of any reserved or protected forest, I am in no way connected with that. Because he was the beat officer of Namuna Ghar. Admitted fact, I was the beat officer of Namuna Ghar. Now, I am taking to the evidence. And he has repeated, even in paragraph, page number 126, he repeated the same thing. I deny the charges on the following grounds. I was never posted at beat officer Namuna Ghar, thus did not work. This is not important. That is relating to Portmore Vrindavan Reserved Forest. That is important. That order was not there, so he has stated about that also. Then kindly come to the first witness. This is page number 158, Ramchandra Singh. Now, in the chief, he said, when I was in charge of Krishnabad range, I have received a letter from DFO that Shri Hamza, forest guards to be posted at beat officer Namuna Ghar under the control of camp officer Namuna Ghar. Accordingly, Shri Hamza has started functioning as beat officer Namuna Ghar when he was submitting the 2 diaries directly to range officer initially. I objected to that and advised him to route it through camp officer, for which he has agreed. This is what he has stated in the beginning. Then questions by presenting officer.
He says as a beat officer.
A beat officer Namuna Ghar.
Correct.
Here it is Portmore Vrindavan Reserved Forest. That is a different block, and it is near Namuna Ghar that is mentioned in the charge sheet itself.
You said you were never appointed as the beat officer.
Of Portmore Vrindavan Reserved Forest. Namuna Ghar, I was there. Can you say Shri Hamza is working where and what capacity in your range? Hamza was working as a beat officer Namuna Ghar. Whether Shri Hamza was submitting his 2 diaries as beat officer Namuna Ghar, yes, he was submitting 2 diaries. Whether Shri Hamza has taken over the charge of the beat and any record is there on paper, I don't remember about the paper. Whether Shri Hamza as a beat officer has any time intimated to you either in writing or orally that illegal felling has taken place in his beat, no, he has never intimated me about the same. When you have inspected on 27 February, whether you have directed any transit passes signed by Shri Hamza beat officer, I remember vaguely that transit passes was signed by camp officer and in some places beat officer. I vaguely remember.
Whatever, I remember
Yes.
vaguely, after such a long time, yes.
Yes. No, this deposition was taken immediately. It is of 97. It's not long time. Then do you have have anything to say after seeing the documents as above? It looks in TP bearing number this, the forest guard Hamza has signed. It looks.
Whatever.
Then we can see the document. Now, the charge number is 1 is read out to witness. I can say that the reply should be ascertained from mobile squad who has handled the case. Kindly consider this. Charge number was illegal felling of tree, and that also in the near the Namuna Ghar. Now, when the question was asked to him, he said, I can say that the reply should be ascertained from mobile squad who has handled the case. The article of charge 2 is read out to the witness. I can say that the reply should be ascertained from mobile squad who has handled the case. Charge number 3 is read out. It appears that Shri Hamza also indulged in forgery of transit passes. It appears. Then the presenting officer argued, and thereafter. Now cross-examination. I'm coming directly to the relevant questions, Your Lordship, instead of reading the entire one. Question number 4. Whether any TP book was issued to Shri Hamza by the range officer to Krishnabad? No. Whether any LMB is issued to Hamza by...
What is this TP book?
This is classic passbook.
Okay.
Because from that only we can cut down the receipts. Whether any TMB was issued to Shri Hamza? No. Then, whether any marking hammer was issued to Hamza by RO Krishnabad? No. Whether any passing hammer was issued in the name of Shri Hamza? No. Then, question number 10. Whether have you seized any TMB, LMB, TP from Shri Hamza? No. Then, have you noticed any other shortcoming in Shri Hamza earlier than the alleged mistakes? No. In your deposition, you have stated that on 26 you have seized the TPs. Can you say how many TPs were seized on those days? 8 TPs were seized on 26 and 3 TPs were seized on 27th respectively. Then, (14) in how many TPs you have noticed that Shri Hamza has signed? Direct question. 4 to 5 TPs he might have signed. He might have signed. There is no acknowledgement. Even those documents were not sent to anybody for verification also. Even the authorities have not compared those TPs with the signature of Hamza. That also has not been done. Then, whether as range officer have you accounted for the seized material? No, I have not accounted for the same. Are accounted by the mobile squad. Then, the next witness is page number 171. This I have to read, Your Worship. On 27 to 1996, Shri Ramchandra Singh, range officer, was asked me to accompany to Namuna Ghar, saying that there was certain illegal felling and transportation taking place. This has happened at 13 hours. At about 13:30 hours, we both went in the department vehicle to Namuna Ghar area. We have not found any timber in the plot of Shri Muhammad Khan, but could find some logs along with some laborers in the adjacent plot belonging to late Shri Devi Das. The laborers told us that some loads of timber have already gone and they are waiting for the vehicle to transport further. Adjacent to this plot was reserved forest area, which is Portmore Vrindavan block. The range officer has advised me to check up in the passing hammer in the Devi Das plot. I found the passing hammers marked on logs. We found more number of logs in the adjacent forest reserve area also. At 15:15 hours, we started back from that area and went to Teja Engineering Sawmill, Hathi Tapu. Though no timber was found in the mill, but the range officer had collected the TP supposed to have transported from the plot of Shri Muhammad Khan. Acknowledgement was given to manager. At around 15:50 hours, we proceeded to Sea Island Sawmill, Ograbaj. On the way, the range officer Krishnabad has taken the register from Namunagar. On reach the Sea Island Sawmill around 16:30 hours, we have seen certain logs for which TP is taken from the mill manager. As per the TP, the timber was transported from the plot of Shri Muhammad Khan. The volume mentioned in the TP was 7 this of paddock. Then at 16:45 hours, we have left for Kadakachan Silver Multipurpose Sawmill. On our arriving Kadakachan Sawmill, we have seen the logs lying there and taken up the TP from the mill manager corresponding to those logs. As per the TP, the transportation was from the plot of Muhammad Khan and 14 logs in number of volume this of hardwood. At 18 hours, we left the place. The range officer proceeded to meet the DFO. On the next day, at around this, I again accompanied the range officer to Namunagar, where conservator of forest has also come. I noticed the staff from mobile squad doing the work of seizure in the field. I returned at 14 hours on the same day. The next day on this, I received a letter from forest ranger containing a direction from DFO to take the charge of Namunagar camp. Accordingly, I assumed the charge of the camp on 4th March 96. On that day, I got a list from the range officer, which was received from the mobile squad, which are one list containing the logs seized from the plot of late Shri Devidas, numbering 25 logs with a volume of this of hardwood. Other list containing the logs seized from the reserve forest Portmore Vrindavan reserve block, numbering 62 logs with a volume of this of mixed species. Then along with the same some forest Mazdoors, we went to respective site on this and started transporting of logs to range office Tutnabad. Then I accounted for the logs in range office registered Tutnabad. On this, the CCF has inspected the range officer Tutnabad and checked the logs. The CCF instructed to dispose of the logs as to avoid deterioration. Then from this, I started transporting the logs to Kadakachan depot and completed the job by 5th July 96. All the logs were transported through proper invoice. Then I was transferred on this to Port Blair and handed over all the documents. Now questions, Your Lordship, by presenting officer. May I please, Your Lordship? During your tenure in question number 2, 1994, who was the beat officer? Shri Hamza was the beat officer during the period. Now, question number 5. If any diary is shown to you, can you recall? Yes. Did Shri Hamza ever refuse to perform the beat duty assigned by you? No. He has never refused to do the duties.
Simple question. It appears, presumed, all these things are because the disciplinary proceedings are continued or decided on the basis of preponderance of probability. Now the question is, what could be termed as a preponderance of probability? It is more a relative and the objective words or the sentences one has to understand in that perspective. Now, authorities being the fact-finding authorities answer. You say no evidence. It does not really rule out that there is no evidence. If the evidence was that, yes, the petitioner cannot issue this, nor has issued anything, and yet the employer have gone and say that, yes, you are guilty, I can understand on the ground of publicity. But if there are somewhat a little evidence, may not have that much of a degree as in a civil law, or may not have that much of a degree as under the criminal law. That does not really make the entire judgment to go. If there is some probability, there is something which the fact-finding authorities have found. In that event,
Your Lordship, charge is of such a nature, Your Lordship, that it totally depends. Your Lordship, kindly.
Can it be at this stage, can a court, writ court, more particularly mandamus court will go into those nitty-gritty of the every words, every bits of the evidence?
No, Your Lordship, I am not saying that. I am saying.
You said on the ground of no evidence. I was also taken aback. Yes, definitely what you say. If there is no evidence, then certainly it's a question of power.
Your Lordship, it appears, Your Lordship, whether that is in evidence.
That is again, I'm saying it's a question of intention or the interpretation.
Your Lordship, it appears, it looks cannot be, Your Lordship.
Language,
no, Your Lordship.
Language,
may I submit, Your Lordship?
Everything has to be seen in this regard.
Our decisions, Your Lordship, I could not bring it today, but there are decisions.
Bring it and show it. Looks, appears. These are all not a positive.
These are surmises and conjectures, Your Lordship.
I
These
don't think so.
based.
Because you have shown certain documents.
Your Lordship,
how can he say that this is a question of signature?
Other evidence, Your Lordship, because they have
the question
said, Your Lordship, the same thing and document. The transit passes, Your Lordship, those were exhibit. And they are the signature of camp officer, that my signature itself is not there. That's what I'm submitting.
That is what you come straight away to this, that these transit passes which forms or which is the foundation of the entire article of charges. Look, these were not.
Yes, all annexed. So, all documents are annexed.
Have you taken those plea before the?
Yes.
Before the tribunal?
Beginning, it's my case that I'm not.
Did you take that plea before the tribunal?
Before the tribunal.
Then why the tribunal rejected it?
Not looked into. That is whatever has been said is sufficient.
That these were not decided.
Yes.
Then it can be at best a case of a remand.
Your Lordship.
Sure.
Your Lordship, basically the decision is at page number 496, para point 5.5. This is the two paragraphs. Rather, rest everything has been pasted, Your Lordship. Whatever the appellate authority has said, just completely it has been pasted like this.
Which page?
Page number, just a minute. Page number 495. 495. In the instant case, the applicant was given the opportunity to defend himself at every stage of proceeding. The disciplinary authority and the appellate authority in their orders have given detailed and cogent reasons based on available evidence to hold the applicant guilty of conduct. The respondent have thus taken care to comply with the principle of natural justice, rule of natural justice. The disciplinary authority based its findings on the evidence of the applicant's colleagues and seniors who are professionally involved in the day-to-day activities of the department and were also familiar with the rules, procedures, and practices followed in the field. From the details given in their reply to the OA, it is evident that all care was taken to follow the statutory rules governing the conduct of the disciplinary proceedings. As has been observed above, the disciplinary authority has given very detailed and cogent reasons for arriving at his decision of holding the applicant guilty of the charges made against him, and the findings of the disciplinary do not suffer from any perversity. We agree with the findings of the disciplinary authority that the preponderance of probability based on all available evidence indicates that the applicant was guilty of the charges made against him, that is dereliction of duty in not preventing illegal felling of trees and fraudulent issue of transit passes. Considering the gravity of the crime, the punishment of dismissal from service is considered appropriate. We have tested the impute orders and the actions of the respondent in this matter. Again, the paragraph is laid down.
True. Because there are very limited
Position of
scope,
Blair has been
limited
stated
scope
here.
of judicial the scrutiny, very limited. Since perversity is one of the ground, that's why I permitted you to make such a submission.
Your Lordship, that I am
And
taking it down, Your Lordship. I can show.
I do not find that the perversity can be
Your Lordship, I
can be
can,
established in this regard.
I can establish, Your Lordship. I can show the transit passes. Clearly, the signature of camp officer is mentioned and my signature is not there. And that plea I have taken since the beginning, from the disciplinary authority till the OA. One at least, Your Lordship, may kindly see the one, at least one document. Page number 353.
Yes,
One document I'll show you, rest others are also there. Page number 365.
yes,
This is the transit pass about which that Ramchandra has spoken about. 97233. One I am showing. Kindly see the bottom signature, camp officer. आज किसका सामने मूव हो रहा है?
yes,
365, Your Lordship.
yes,
97233. Kindly come to that, Your Lordship.
Yes.
Once. Kindly see the signature. It is of camp officer.
yes,
I am not the camp officer, Your Lordship.
yes,
And he has relied upon this particular document to say this is my signature. It appears that it is my signature. It doesn't appear also. Just, Your Lordship, I know, Your Lordship, that court is not an expert to verify the signature. But by seeing itself, one can find out that this is not my signature. My signatures are appearing in other documents. There is no match with that signature. It's a signature of the camp officer. One camp officer is saying that I have signed this. It looks like I have signed it. On what basis? Some logic should be there. Neither my seal is there, nor my signature is there.
yes,
365, Your Lordship.
yes,
Kindly see 97233. This is the number which he has given.
yes,
So none of the transit passes contain my signature, all signed by the camp officer.
yes,
Now the camp officer, he is the camp officer, Your Lordship. Ramchandra was the camp officer.
yes,
So in order to save himself, he has blamed me. He has become a witness to this particular case
correct,
because camp officer is the head of the area.
true,
So, Your Lordship, my submission is that rest, I just wanted to show some more papers, Your Lordship, and I will be placing the decision.
yes,
Your Lordship, kindly come to page number 173, question 11. This is important, Your Lordship, because there are different version of the witnesses of the authority, and this is not in the cross-examination. In the examination in chief by the presenting officer, he has said, since you have said that your deposition that certain TPs from the respective sawmills, can you recall who has signed those TPs? There was a signature in the name of camp officer, Namunagar, but I can't say who has signed it. This is their witness. And he is saying that the signature is that of the camp officer. And I was not the camp officer. It is their witness. He could have said that it has been signed by Mr. Hamza. Then how much distance this area, Portmore Vrindavan block, would be from Namunagar camp headquarters? In between 3 to 5 kilometers. Why I am saying so? Because I was the beat officer of Namunagar. And this particular place is Portmore Vrindavan Reserve Forest. That is another block which is 5 kilometers away from Namunagar.
1 kilometer away.
1 kilometer actually from road he is asking. I have seen that, Your Lordship.
1 kilometer
Now for this
from
case,
the camp office.
how far this clear felt site is from roadside, not camp office? Your Lordship, we kindly see. The question is roadside. From roadside, how much distance is there? He said 1 kilometer from roadside. But from Namunagar camp office, it is 3 to 5 kilometers. Then again, Your Lordship, let me complete, Your Lordship, this way. Do you mean to say whether the forest guard functions as per the assignment of duties by the camp officer? As per the directions of the camp officer, he performed the duties. Now, since you have said you have been seen several logs at the site and the sawmills, can you able to suspect any involvement of Shri Hamza forest guard? I can't say. They are the witness of the authority. Since you have taken over the charge of the camp Namunagar immediately after suspension of Shri Hamza, have you traced out any mistake on part of Shri Hamza? No, I have not. Then, have you stated in your tenure as a camp officer Namunagar, you have seen the spots for felling and transportation of logs taken place? Have you ever tried to find out who is the accused or culprit in doing this?
How
No.
can I say?
No, when they were so perfect, your lordship, in identifying somebody else's signature to say it is Hamza's signature, they should have said that Hamza was involved. Your lordship, let us see, your lordship. They could have said Hamza was involved in all these things. It's their witness, not my witness. Their witness themselves are saying that they are unaware of all these things.
You are just trying to take us to reappreciate the entire
No,
evidence, to
Lordship,
go into those,
No, your lordship.
those,
Let me
those,
show that
whatever.
taste.
Only thing is, the allegation is very clear against you that there was a felling of the trees. This was your obligation or your duty to inform. You did not inform. There has been a transportation which contains certain TPs. It says that it came from Muhammad Nawaz,
Muhammad Khan's.
Mr. Muhammad Khan's place, land. There is a nearby reserve forest area also. So there were certain TP mark on some of the logs which are there in the reserve forest area also.
I am not the holder of TP. I am not the holder of hammer.
Now the question is that who has put the TP and who has done it. It says that you were moving it, you were moving around the said area. You were supposed to do a lot of, you are supposed to inform to the concerned officer, having not informed or gave a very free passes to it, and that shows that you are guilty of it. This is what the total evidence that has come.
Your lordship, that first part, charge 1, let us assume, your lordship, charge 3 has not been proved. In any circumstances, it has not been proved. So for charge 1, your lordship, this very principle is there. Such dismissal from service itself, camp officer.
That is another, whether really it shocks to the conscience of the court that the penalty is incommensurate with the gravity of the offences or the charges.
And moreover, when we are aware, your lordship, that the entire authority is of the camp officer. I am a very low level officer, not practically an officer also.
Because you are a grassroots officer. Camp officer remained in the camp. You are a grassroots officers who really roam around the areas. And you keep the surveillance, you keep all these, you continue monitoring. There's a more responsible duty which is given upon you.
Your lordship, I'm again repeating, your lordship, not
Whatever.
I will be relying upon certain decisions. Tomorrow I will place.
Place it, whatever you want to place it, I don't mind. As I never shut any of the advocate to give the judgments. But I always express my mind very clear.
No, I will complete it, your lordship. Just your lordship. The other witness also, I just want to show
I have gone through a bit fast. And you have inserted certain questions that I have gone through. I think those questions you wanted to rely upon.
Your lordship, I just wanted to rely upon those questions. Because almost all the witnesses have said, I don't know. I can't say. This is the answer.
For those judgments, line of judgments, I don't think so. The latest judgment is, I think, the Umesh case.
Now the scope has been reduced a lot.
That is what I'm saying. Umesh case is the last one known to me.
But even then, your lordship, the facts, if looked into, your lordship, the allegations.
Let us see. Definitely, if you impinge upon the penalty, then definitely we'll consider that this offense, one serious lapses, whether that would really create.
And this is the single instance, no other instance at all.
Let us see.
Your lordship.
What is it? Yes. Tomorrow as first matter.
Your lordship. Yes.
And let this matter be listed tomorrow as a continuing matter. Yes, let us come at 2, single bench. What can be done now?